Now we're going to go back to our program. It's my pleasure to introduce Jamie Doherty, Jr. Jamie is a respected healthcare attorney and a friend to Montgomery County Medical Society and our members. Jamie is a principal in the Maryland law firm of Pecor and Doherty, LLC, a boutique law firm focusing his practice on representation of individuals and entities in the healthcare industry, including individual, group, and institutional healthcare providers and vendors. Mr. Doherty was formerly Vice President and General Counsel of New American Health, a Maryland Medicaid MCO, and served as Senior Counsel for Integrated Services at the Johns Hopkins Health System in Baltimore, Maryland. He has practiced in-house for a Fortune 500 proprietary hospital chain and was contributing editor at the American Health Lawyers Association in Washington, D.C. Mr. Doherty maintains a faculty appointment at the University of Maryland Francis King's Carey School of Law, where he teaches healthcare law and policy. He taught the course Legal and Ethical Issues in Health Services Management for 17 years at the Johns Hopkins University Bloomberg School of Public Health. Mr. Doherty is a past president of the Board of Trustees of the Baltimore Medical System, a community health center in East Baltimore. Mr. Doherty is a graduate of the Columbus School of Law at Catholic University of America in Washington, D.C. Just a reminder, this program is being recorded, so we ask that you continue to mute your microphones. Mr. Doherty will speak for approximately 45 minutes and then respond to questions afterward, which can be submitted via chat. This presentation will be posted on Montgomery County Medical Society's and MedChi's YouTube channels soon for future reference. We ask that you now turn your attention to Mr. Doherty as he shares his expertise on finding the best compensation model for you. Jamie, thank you very much.
Thank you very much. Thank you, everybody. I'm just about to share my screen, see if we can get started here. Yeah, if you were with us last week, I went over some of the very basic elements and things to look at in the physician employment contract itself, restrictive covenants, termination provisions, all that kind of stuff. We're going to focus a little bit more closely on compensation models that we see in our practice. The purpose of the session, provide you with some detailed insights into current compensation models and issues for employed physician contracts. Basic terminology and concepts we're going to look at. You'll hear me talk about WRVUs, salary survey data, and salary caps, and I'll explain what each of those are in turn. So WRVUs are work relative value units. And some of you may know this, but the amount Medicare pays for physician services depends upon the number of RVUs, relative value units assigned to the service. Some of those units are for the cost of the overhead or the cost of injectables or whatever. The WRVUs are the work component of the amount of physician effort it took to deliver that particular service. So the Medicare fee for a service will be the number of RVUs in that service times a dollar conversion factor. That's how Medicare figures out what to pay for a particular code. WRVUs are the number of RVUs assigned to the physician work effort component of the service. And it's used as a measure of physician productivity. So for each service, the WRVU says this is how much physician effort it took in order to render that service. And one of the things they do is use salary survey data because it's extremely important for health systems and many employers to make sure that they are paying what they call fair market value. That's important. We'll talk a little bit for the Stark law, for the anti-kickback law, for IRS regulations, but people don't want to overpay more than fair market value, and people want to get paid at least fair market value for what they're doing. So how do you determine what fair market value is? We're going to talk about that. In the early days of the RVU system, the government would say, we don't like your fair market value. And we'd say, well, we have an accountant that says this is what it is. It's gotten a little bit more scientific since then. So there are certain associations and companies that conduct annual surveys of physician compensation and productivity. Three very common, there's a lot of them, but three very commonly used government endorsed surveys. The government has actually said, if you get a salary survey from one of these sources, we consider that to be a valid salary survey. We're not going to challenge the methodology or the results. So many people use these. First is Medical Group Management Association. The second one is AMGA Consultants. And then there's third one is another very common consulting agency called Sullivan Cotter. And the survey data is specialty specific. So there'll be surveys for primary care, family practice, radiology. The surveys will survey amount of physician effort and sort of the dollars by specialty. So the survey data is used by hospitals and health systems to set compensation for employed physicians. And it's to provide objective legal support and justification for the reasonableness and fair market value of the amounts paid. So if you overpay a physician in a nonprofit hospital, that is considered what we call private inurement. The IRS will come after you. If the hospital can say, oh no, we had Sullivan Cotter do a salary survey and we are at the X percentile, this is fair market value compensation, then you're fine. But you're going to meet IRS standards, you're going to meet OIG standards for the anti-kickback statute and for Stark Law. So that's why health systems want to use these. These surveys are rarely used by private physician practices. They don't have the same concerns. They're not worried about referrals in a hospital. They're not for profit, so they're not worried about the IRS. So if you're going to be employed by a hospital or health system, it's helpful to understand how the survey data is used and how it's misused. It is used to determine fair market value and to make sure the hospital is sort of within those guidelines. We have seen cases where the hospital will tell a physician, oh, the survey data says I can only pay you 45th percentile, so that's why we're giving you a lowball salary. And in fact, that's not actually the case. That you could be fair market value and be higher than that. So you always need to sort of double check their numbers, So these are the key terms when they're looking at physician compensation and productivity. Total annual cash compensation, TCC, it's sort of all the cash the doctor is going to get. The productivity of the physician, measured by the work RVUs. Professional collections, that's how much money did they actually collect for your personally performed services, usually minus any kind of refunds. Compensation per WRVU, compensation per hour, and any other aspects of physician compensation and productivity. Salary caps, you'll hear this word. This is relevant mostly to tax-exempt organizations, which is nonprofit hospitals or their subsidies. To the best of my knowledge, a vast majority of the hospitals in Maryland are not for profit. And we're very unusual that way. One of the reasons is as you know, we have the Maryland Hospital Rating System. And I used to work in a large for-profit hospital company. They're not interested in Maryland if they can't determine their own rates. You have to go in front of the Health Services Cost Review Commission and the total cost of care model, and it's very complicated. But for-profit hospitals are not interested. So a vast majority of the hospitals in Maryland are tax exempt, and you'll be running into these issues if you're employed directly by a hospital or by a hospital subsidiary. So the IRS, if you're a nonprofit hospital, has deemed certain comp models structurally problematic because they result in impermissible sharing of charitable assets. So what that means is, in a not-for-profit company, all the charitable assets are supposed to be used for the charitable purpose. And if you use them for something other than a charitable purpose, then it could be private inurement. It's a violation of IRS standards and tax law. So one of these, so in a for-profit company, if you buy a share in that company, you have unlimited upside. There is no law that says how high the value of that share can go. If you have a relationship financially with a not-for-profit hospital, there are rules. If you have an unlimited upside that looks like you're owning a share of stock, that violates the rules because private individuals cannot own a piece of a tax-exempt nonprofit hospital. They can be paid fair market value for services they render. So an example I could give is if the hospital needs a CEO and the going salary in that market for a CEO is $500,000 a year. The IRS doesn't care that you spent $500,000 of charitable assets on a CEO because that's fair market value. It's a service you needed. That's fine. If you overpay the CEO, you give the CEO $1 million when the going rate is $500,000, the IRS says that $500,000 is impermissible inurement to an individual. That individual is taking $500,000 worth of a charitable asset. So if you have a payment methodology with physicians where there's an unlimited upside, that looks like a shareholder distribution. And how could it be fair market value for a specific service rendered if it could be a smaller amount or it could be an unlimited upper amount? It's hard to say that's fair market value. So the penalties for violations are excise taxes levied against the hospital, management, and physician. So these taxes, so for example, if you are overpaid $100,000, the tax on that is $200,000. They just absolutely don't want this to happen. If a hospital is really abusive of its charitable assets and overpays people, engages in private inurement routinely, they can actually lose their tax-exempt status. So if you have caps on the physician total cash compensation, that eliminates unlimited upside for the physician, and it protects the hospital, the management, and the physician. So having a salary cap in a nonprofit context is really important. The cap also helps to ensure reasonableness, fair market value of total cash compensation for, as we said, IRS tax purposes, federal Stark self-referral law purposes, and the anti-kickback law purposes. For Stark and anti-kickback, if you overpay over fair market value, the government is going to assume that overpayment was in order to improperly induce referrals to the facility. And that can have serious financial and actually even criminal consequences. So the caps really help to protect everybody involved in the transaction. And the salary survey data is used to set these caps. So the compensation being offered to physicians, there's two basic models that we see with some variations. One is you get a base salary plus a bonus calculated on some basis, or pure productivity. You're getting pretty much a piece of what you bring in, of what your personally performed services are bringing in. You can get a guaranteed total salary. That is rare these days. Government, if you're working for VA or something like that, or an organization like, Kaiser Permanente Medical Group may just have a flat total salary. They probably have some internal quality incentives as well. All right, so the base, compensation model, you're gonna have your base salary, you're gonna have your bonus, and you're gonna have an annual cap. So if your bonus hits the annual cap, then that's just an absolute cap. You can't go above that. So the base amount, and right now I'm talking about new physicians out of residency. So it's usually set at one of the following: a third-party salary survey benchmark level based on historical productivity. What do these physicians in that category typically produce? And if we take what they typically produce in WRVUs and we multiply it, by the standard dollar factor, then that's what we get. So if historical productivity measured by WRVUs was at the 60th percentile on a salary survey at that particular facility, the base compensation is going to be set at the 60th percentile total cash compensation that appears on the same surveys. That's how they get their number. So the standard starting rate for the specialty for new physicians in this health system or private practice, that's how they determine it. The base guarantee, if there's any guarantee, it's usually only for 1 or 2 years. So in the beginning, they may well guarantee you a certain base. You're going to, no matter how productive you are, you're going to get this base amount because you have mortgages, you have car payments, you have children in school. You need to know that you're going to be earning a certain income. Now, sometimes the base is going to be dependent on a physician's maintaining some minimum level of production as measured by the professional collections or the WRVUs. We have run into situations where physicians were just not being productive. And sometimes that was personal issues. They had a substance issue, they had a medical issue, they were going through a difficult divorce. They just weren't producing to the minimum. And so what happens then is the hospital has protected itself. They don't want to overpay. But so if the threshold hasn't been met, they're not going to fire the physician necessarily. They're going to basically lower the base either this year and say, okay, you're not meeting target for the last couple quarters, so we're going to lower your base, or in a subsequent year. So you're not going to have to pay any money back under that model. You're just going to have a lower base for subsequent years. Sometimes, if they feel that your productivity was so low that the base salary was just unreasonably high, your contract will say you actually have to repay the excess. So you were getting it as salary, but you have to repay that. And it looks more like a loan. You're going to have to talk to your tax planner and you're not going to have to pay taxes on an amount that you got and then had to repay. But that's just how they have to deal with it if someone's not even in the zone in terms of WRVU productivity. All right, types of bonuses. Productivity bonuses can be measured by typically we see either WRVUs, the amount of effort that went into it, or cash collections. How much money did you actually bring in? There's very often what we call a quality/citizenship element. That could be measured by patient satisfaction surveys, score on quality metrics. For example, for PCPs, number of patients receiving an annual flu shot, or now, people receiving the COVID boosters. Are you providing an adequate amount of charity care in that practice? Are you taking emergency department call? Are you serving on hospital or facility committees? All of those things can be part of the quality citizenship factor in a bonus methodology. The other factor is an awful lot of hospital captive medical groups these days are sharing in quality and utilization bonuses paid by third-party payers. So if that group is participating in the Care First primary care medical home and that group receives a bonus, there will be a way of allocating portions of that bonus to the participating physicians. Similarly, if there's shared savings in an ACO, accountable care organization, and the ACO is distributing those kinds of monies, that will be an element in your individual bonus, because they're trying to induce groupthink. They're trying to get the group to act as a group and meet the quality metrics and meet the efficiency standards. So types of bonuses, productivity bonuses, sometimes only earned after some minimum productivity level is reached, as measured by WRVUs or cash collections. Because the practice is going to want to make sure they're only paying you a bonus if you are paying for yourself. So if you are paying for your own salary, you're paying for overhead, and you hit some threshold, then productivity bonus is payable after that. And again, it could be WRVUs based on the amount of effort, or it could be cash collections. Various bonus methodologies have different advantages and different disadvantages, and we'll take a look at some of those. So the physician's total cash compensation under a bonus will usually be subject to an annual cap. Just for example, they'll say the cap is the 90th percentile of total cash compensation in the salary survey that we are using for our area that's relevant for us. Pure productivity compensation model. There are a couple of different ways to get at this. One is a WRVU model, where they use the WRVUs to calculate your productivity. The next one is revenues minus expenses that they use to calculate your productivity. And the last one is percentage of collections. So the WRVU model, they'll look at the individual physician total cash compensation, the total annual WRVUs times a dollar figure payout rate. It's helpful to know the productivity of other new physicians in the practice as a prediction of your own. How are the other docs doing? What's their productivity? I mean, what's the patient load? How many WRVUs are they generating? What's the zone that you should be in and can expect? It's also important to be familiar with the most current salary survey data for your specialty. So if you're being told this is based on, the Sullivan-Cotter survey for rheumatologists in this market, the facility should be willing to share that data with you and your financial advisor. The advantages of a WRVU model, these apply to the base plus bonus model using WRVUs for a bonus, and to the pure productivity model and the WRVU model. It rewards highly productive physicians. It's not dependent on the effectiveness of the employer's billing and collection department. So this is just based on your effort. And we'll talk about this, but if you're on a percent of collections model, your pay is going to depend on how well the facility does in collecting the billings based on your personally performed services. So if their collection rate is 50% of all your billed charges, your compensation is going to be dramatically reduced. If their collection rate is 85 to 90% of your personally performed and billed services, it's going to be much higher. But in a WRVU model, it doesn't matter how the billing and collection department is doing. It matters what you are actually doing. This is also not dependent on the payer mix. So it can be important where the hospital is located, whether it has a large amount of Medicaid and charity care. So if you're at an urban hospital, at Johns Hopkins or University of Maryland, there's going to be a very large percentage of Medicaid and charity care, which is going to affect the amount that the hospital collects. If you're in a suburban hospital, a Montgomery General or a Greater Baltimore Medical Center, there's going to be a lot less Medicaid and a lot less charity care. And so the payer mix is going to be richer. They're going to collect more. But the WRVU model, it doesn't matter how well the hospital is collecting the money, and it doesn't matter what their payer mix is. What matters is your personal productivity. Disadvantages of WRVU model. Most residencies don't track WRVU, so it's difficult to know how much you will earn in that kind of a model. It encourages, what we call every man for himself behavior. Physicians essentially are competing for WRVUs rather than sharing patients. If I consult with you and a patient, you're going to rack up some RVUs. If I keep the patient all to myself, I'm going to rack up some WRVUs. And there are people that think this model, sometimes discourages appropriate consultation among physicians. It can also hurt new physicians that have no patient or referral source following, unless there's surplus volume at that facility or the senior physicians are feeding you. They're giving you certain kinds of things. All right. Now, the revenue minus expenses model. That's individual physician total cash compensation. That's the physician's share of total allocated practice revenue minus the physician's share of total allocated practice expenses. Very, very common model in private practice. It's very important to understand how revenues and expenses are measured and allocated. It's important to have some say over expense decisions if you possibly can. And expenses, if you are a physician who just the actual costs of your type of practice, you use a lot of injectables or a lot of equipment, the expenses allocated to your practice are going to be higher than someone who just uses an exam room. It's just the way it is. Staff costs are going to increase under health system employment because of higher benefit costs. Health systems typically have much richer employee benefits than a private practice will. Private practice will just have whatever they have to have in order to attract quality people. A large institution just has a history of all sorts of rich employment benefits. And those are, the more of those costs, the more those expenses get sort of netted against the revenues that come in. Advantages and disadvantages of the revenues minus expenses model. Advantages, depending upon how revenue is allocated, may encourage more group-like behavior. We're all in this together. It will reward a cost-efficient physician. If you manage to keep your expenses down, your revenues are going to be higher. Disadvantages, again, it can depend upon how effective the employer's billing office is. If your revenues are down because the billing office is not doing a really good job, that's going to impact your revenue and it's going to impact your personal compensation. And it is dependent on the payer mix. Do you have, well-paying private payers, or do you have a lot of Medicaid? Is there a lot of charity care in that particular hospital? Dependent upon the overhead. In a health system, you may have almost no control over your overhead. But again, you just can't avoid higher health system benefit costs. It's just it's just the nature of the beast. All right, percentage of collections model. That's the individual physician's total cash collections. And you're going to get a percentage of professional collections received by the employer for personally performed professional service. Very common model in private practice. The Stark law, the Stark self-referral law that I'm sure all of you have at least heard of, it's a self-referral law. They don't want you to have a financial interest in services that you refer to, because they believe that creates an improper incentive to over-order those services. So in these models, even if you're part of a group, they really can't give you a percentage of your own collections for certain ancillaries ordered by you: lab, x-ray, physical therapy, DME. So if you got a percentage of all the labs you ordered, the government basically says that's going to encourage you to order more labs than are necessary, and that's an abuse, and we don't want that. What they typically do is say, look, we're going to throw all of the ancillary revenue into a pool, and everybody's going to get it based on, so if there are 10 physicians, each one is going to get 10% of the ancillary pool. That way, no individual physician is being directly compensated for how many labs, how many x-rays, how much PT, how much DME they order. And that's just, you may be frustrated if you order a lot of ancillaries and you think you're accounting for a pretty big chunk of the income that comes in on the base of that, but the Stark Law just says you cannot do it. You can get an equal share of what the whole group does. You just can't get a percentage based on your personally ordered services. The advantages and disadvantages of the percent collections model. Advantages, very easy to track. You know exactly what the collections are. They run reports, and it rewards highly productive physicians. The more they collect off your personally performed services, the more you're going to earn. Again, disadvantages, it's dependent upon an effective employer billing office. It's dependent upon, is it a decent payer mix, or is it an urban payer mix with a lot of Medicaid charity care? Can encourage every man for himself behavior. You want all the collections you can for yourself. And this isn't as big an issue these days, but I've still seen it happen. When hospitals are implementing EMRs, it was suddenly had a massive and dramatic impact on people's productivity. They were implementing the EMR in stages. They were, training people. And even now, with a lot of people having EMRs, I've seen a productivity hit when people are changing EMRs, their old vendor is going out of business, or they've decided to adopt a new vendor, or a large system like Hopkins or Maryland buys another facility and says, you're now going to be on our EMR. There's going to be a hit on productivity in adjusting to a new EMR. Sometimes, if there's something like that is in the works, you can negotiate a hold harmless provision. It's like, look, I know you're going to change EMRs and you have good reason for doing that, but I want to be paid the same during that transition period. I want to be held harmless because the reason my productivity is down is due to no fault of my own. I'm working just as hard as I was, but I have to put more time into EMR implementation. So EMR implementation, in productivity-based bonuses and compensation models can be negatively impacted. Again, you may be able to get a hold harmless. If not, you might be able to, sometimes they have provided scribes. People will, sort of take your notes and enter them, so you don't have to be taking as much time for that. Another aspect of facility-based compensation or health system compensation, if you're going to be doing substantial administrative services for a health system, there should be, and usually will be, separate administrative stipend in addition to compensation paid under the above models. It's usually determined based on an hourly data from a survey. It will likely require you to fill out monthly time logs documenting services and hours. They have to be able to prove to the IRS and the OIG that you are actually getting paid for services that the facility actually needed. Sometimes if you don't like or not particularly thrilled with your base plus whatever bonus you're getting, they can find an administrative position that will allow you to have additional responsibilities, but it will allow you to earn additional income kind of outside your base salary cap. Benefits. In evaluating your total compensation package, consider the effect of more or less generous benefits when considering health system employment versus private practice. So you might think, well, my base and my bonus aren't as good, but if you're working for a Johns Hopkins or a Maryland and your kids could get reduced tuition at one of those universities, or you're getting much better health benefits or better life insurance, dental insurance, pension plan, all of that kind of stuff. So look at your total comp when you're looking at it. Don't just look at the actual salary. Include the benefits. Definitely ask for payment of any hospital, professional society, medical society dues. If there are resources you need to maintain your fund of knowledge, if there's CMEs you need to attend, that should be one of the benefits you get under the contract, and you should negotiate for those. So some of our recommendations on navigating this stuff is, know your own historical data if it's available. How many WRVUs have you generated in a year? What has your total cash compensation been? What kind of compensation per WRVU have you been receiving? What's the practice overhead that gets allocated to you? try to obtain the most recent salary data and productivity survey data for your specialty. Sometimes you can find outdated survey data online. You want the most recent you can possibly get. So there are consultants, at accounting firms and consulting firms that may be able to have access to that. They'll subscribe to it. It's generally pretty expensive for you to subscribe to it yourself. Or the hospital, if they are using that in your comp, they should be able to share that with you, your attorney, or your financial advisor. It shouldn't be a black box and you don't know what they're using. Understand some nuances. There's going to be differences in data based on geographic area. The downtown Baltimore is going to have different salary survey numbers than Western Maryland or the Eastern Shore. And there are going to be differences in data based on functions in the position. Medical directors, a chief, department chair, those are going to have different salary numbers or different survey numbers. Make sure you completely understand the proposed compensation formula. Read it, think it through, ask questions. I recommend that people sort of get sample compensation worksheets for physicians who already work in that model. They can blank out the names, but and if you don't understand it, you should understand it, because otherwise later there's going to be a misunderstanding. And understand what factors are within your control. You can be more productive, or you can cut down on certain expenses, and understand what factors are not. You're not going to be able to do anything about the cost of the facility space, or malpractice, or staff costs, or benefit costs. Those are not reachable by you, but there are factors within your control. Also, this is really important. Find out what types of regular monthly reports you get on your earned, bonus, or productivity compensation. You should get sample reports, take a look at them, and then you should be getting at least quarterly, preferably monthly reports. So if you see that and it's like, uh-oh, the hospital, the billing office is way down in the last 1 or 2 months. Why is that? Did you lose staff? Is there something wrong with the billing system? Have the payers changed how they reimburse certain things? You want to see, you want to make sure it's on a steady keel. If you see a dramatic change in a short period of time, that needs to be addressed. If the collection office got really inefficient in February and you don't find out about it until December, you're going to have a really rude surprise about what your bonus compensation could be. And these are standard reports. The system should be able to generate those and get them to all physicians. You're not asking for them to run a custom report. These are things you should just be able to get. Our other final recommendations, talk to similarly situated physicians who have worked under that proposed formula. Are they satisfied with it? Do they have any tips for you? What do they think are the benefits? What do they think are the disadvantages? So go into it with open eyes, know what you're doing, and hire an experienced attorney or consultant to advise you. This is one of those areas where, as I said last week, I was in-house at Johns Hopkins for 4 years, and I learned if you need a specialist, get a specialist. You want an attorney who understands not just physician employment contracts, but physician comp models. And if you get a consultant, either at a financial consulting office or you have a CPA, they need to be people that are very familiar with physician compensation models, salary surveys, calculation of all of this kind of stuff. And they can advise you, yeah, there's a little bit room to push here, or maybe you can't push in year 1, but you'll be able to push in year 2 when your productivity is up. They'll be able to advise you, but it needs to be people who understand this world. All right, that is the basics.
Okay. Well, thanks very much for that informative presentation, Jamie. I have encouraged everybody to put your questions in chat. We will take those first, and then we are going to ask people to unmute yourselves. I did put a couple of questions in here, and I'm going to take the last one that I put in first, which has to do with the impact. I know this is looking back, not forward, but what about the impact, and do you know of any litigation related to the impact of COVID on decreased productivity, especially as it may lend itself to private practice? I mean, we saw, of course, in hospitals, productivity, was exponentially increased. But what about in other settings that were so affected? And then as kind of a part 2 is, what's the impact of telehealth on compensation What are you seeing in terms of the trends there? I'd appreciate you commenting about those.
Sure. COVID made everything squampus. You know, it had a devastating impact on the private practices. You know, that people just weren't coming in. Sometimes they were down to 30 and 40% of prior volume. It was devastating for us because we got paid a lot slower. You know,
Yeah.
and we also saw really creative arrangements. Like sometimes physicians who just weren't as busy in their private practice, a local hospital might come in and say, "We're busy as all get out." You know, and we'll sort of bring you in on a temporary basis. So some physicians supplemented their income in that way by becoming temporary contractors at hospitals who suddenly had crushing volume of inpatients, and it sort of helped them supplement. But there was kind of nothing that small independent practices could really do. They just couldn't afford to pay people. And I didn't see, we're not litigators. I did not see litigation over this. I knew there were a lot of disputes where physicians are like, look, I've got a mortgage, I've got kids in college, you know, I've got to make a living. And the practice saying, if I had the patients, you'd be treating them, you know, they're just not coming in. So I don't know how helpful that is, but, and the impact on telehealth, I mean, we are seeing that sort of kind of pretty seamlessly integrated into most practices. It's now a regular feature. And there are certain populations, certain inner city populations are much more likely to get telehealth services. Certain elderly populations who have trouble making it for office visits are sort of using that if they have the technical help. But I can't say that we've seen any kind of major impact on telehealth. Plus, it's just been the telehealth rules for the past 2 or 3 years have gone all over the place. There's emergency authorization to do it out of state. There's emergency mandates for the payers to do it. I know that they had to pass a law in Maryland so that it would continue in Medicaid because they found just a dramatically increased access to care for that particular population. So I think it's still settling out. And it's got really weird. We recently just had a fairly large multi-specialty practice got an inquiry from the Board of Physicians that they were updating their PA delegation agreements. And they said, oh, you had people starting to do telehealth 2 or 3 years ago and you didn't tell us? You didn't update your delegation agreement? We're investigating that. And we're kind of falling out of our chairs. It's like, well, first of all, telehealth is not expanding a PA's scope of practice. It's not adding a new service that they do. It's just allowing them to do core services in a different methodology. And I just can't imagine that anybody 2 years ago in the midst of COVID were saying, you know what our main priority is right now? We need to update our PA delegation agreements to reflect the fact that they're doing some telehealth. But that actually, if any of you are into that, that is important because one of the things the board needs to know is what setting that PA is practicing in. If they're practicing telehealth in the office and the patient's at home, that's one thing. If they're located in Virginia or Delaware and they're licensed here, the board really needs to know what setting you're practicing in. But so that has just been a bizarre thing. But I think it's too early to tell how telehealth is going to shake out because we're not back to a new normal yet. If we ever get there, it's just been very febrile over the last couple of years.
Sure. And this is a follow-up question to that, maybe more of a contracting question, but unless an employer expressly prohibits a physician from having another, say, side gig,
right?
Can the physician choose to do that to supplement their income? And of course, then there is the medical malpractice issue of that, where they would have to carry their own insurance, et cetera. But do you mind commenting about that?
Oh, no, not at all. That's a great question. And it frequently comes up in contract negotiations. First of all, if you're an employed W-2 physician, you actually have what's called a duty of loyalty to your employer under Maryland common law. You're supposed to be working primarily for their benefit. So if they could say that the side gig was interfering with your ability to provide the services that they want you to provide, then that's a problem. What we typically tell people is, if you want to do that, put that on the table up front. Say there's this side gig I want to do, and I want in the contract, it says, number one, I can do it, and number two, I get to retain all the revenues for that. Because if your contract says, you typically sign, an assignment of your billing rights to the practice. In other words, you're not going to be individually billing CareFirst, the practice is, and they're going to be keeping all the CareFirst money. What you're entitled to is your salary and comp under the contract. If you do a side gig, there's practices, and we've seen this, where they said, oh, that side gig money, that's ours. Those speaking fees you got, those are ours, because your contract says we get all of your professional fees, So I would put it on the table that this is what I want to do, either in writing in the contract, or I would even accept a side letter or an email. We know you're going to be moonlighting in an emergency room, or you're going to be doing on call for somebody or something like that. Typically, most employers allow you to do that. They want it to, number one, not interfere with your ability to do the job they've hired you to do. Number two, they don't want it to compete with them. I'm going to go to a competing multi-specialty practice 10 miles away and provide services. They're not going to want to let you do that. And number three, the malpractice issue. If you're going to do a side gig, the contract very fairly will say, well, that's fine. Number one, your malpractice insurance with us is not going to cover that. And number two, you need to provide us with evidence that you do have malpractice insurance for that gig. And it's really important. I had a group of emergency residents from Hopkins several years ago that were moonlighting at an urgent care center. And the urgent care center said, oh, don't worry, you have malpractice insurance. And they gave them a piece of paper. That was a fraud. They were never covered under any malpractice insurance. And when some issues came up, they went to Johns Hopkins and said, will you cover us? And Hopkins said, no, that's your side gig. We don't cover you for that. And we got very involved. The employer just lied to them, dummied up cover sheets for medical malpractice insurance. And when they called and said, oh, I've had a malpractice incident, I'd like to report, they would say, what's the policy number? Here's the policy number. No such policy number, So again, and that's something I actually didn't mention last week, always get like at least a face sheet, proof of your med mal insurance. What are the effective dates? What does it cover? What are the limits? And then keep that. And you should get that every year. Because if you go to a new employer, they're going to want to see documentary evidence that you were covered for prior acts before you got there. So again, most places, if you want to supplement your income, as long as it doesn't compete, it doesn't interfere, and you have your own malpractice, there's kind of no reason for them to say no. We've been on both sides of that, and we tell our employer clients, let them do it. They'll be happier. They're making more. If you see that they're coming in dragging in the morning because they were up really late doing something, if it's literally interfering, build that into the contract. If they can sit you down and say, you've been tired, you've been showing up late, you're not as productive as you were, you got to cut the side gig. That's a violation of your basic contract with us. But that's not unusual at all. And different kinds of income. Some people teach, some people want to write books and articles or lecture, and some things they really don't care about. If you want to volunteer to be the team coach for your daughter's lacrosse team. And by the way, for that, sometimes you don't need malpractice insurance. If it's a public school, if you go to a public high school and you decide to be the team doctor for the football team, the Maryland Tort Claims Act, you're covered as though you were like a community health center physician. You don't need coverage at all, but it's statutory in Maryland. But if you're going to do it in a new practice setting, make sure it's okay with your old practice setting and make sure you have coverage for the new practice setting. Absolutely, every time.
Well, a specific instance, and we're going to get to these questions that have been offered, is that I've learned of some physicians who are actually doing 2 or 3 or 4 hours of telehealth after they leave their practice. Mm-hmm. And so, sometimes it's these companies where you can, call in for hair treatment or ED or any other issues. And so they're doing more of that. So let me get to these questions. We had a couple of questions, and you did address this last week, but we'd appreciate you addressing it again. Sure. Has to do with the non-compete clauses and the FTC's hearings about these, and whether or not even the possibility of the FTC outlawing those, whether or not it's had any effect on new employed physician contracts or existing employment contracts. Could you comment about that, please?
Oh, sure, absolutely. And I'm sort of assuming everybody's at least vaguely aware of that. But restrictive covenants that basically say when you leave a practice, you can't practice within a certain area for a certain period of time. It's basically to keep you from leaving and stealing patients, stealing staff, competing with the practice that sort of trained you. So they're very, very common. They're enforceable in Maryland. If they're reasonable in geographic scope, they really cover the service area they're trying to protect, and they're reasonable in time. We see 1.5, maybe 2 years. I haven't seen a 3-year restrictive covenant in a long time. But what the FTC, this is kind of shocking in a way. I mean, I've been a healthcare lawyer for 30 years, and I've been dealing with restrictive covenants for 30 years. And for the FTC, I think the impetus of this, and we talked about this last time, was a lot of lower wage employees were being unreasonably restricted in their ability to earn a living. So if you made sandwiches at Subway, you'd literally have a restrictive covenant that says you couldn't go to Jimmy John's. And it was really people, low wage workers, $15 an hour workers. And that was just considered to be an unreasonable restraint. If you're working at Subway, you don't have regular customers who are going to follow you to Jimmy John's. They're just not. Whereas if you're a good pediatrician, you're a good family practitioner, you're going to have patients that follow you. So what the FTC said is we're considering these things to be an unreasonable restriction on people's ability, to engage in economic activity. And we're thinking about banning them. And they're not thinking about banning them for people who work in fast food joints only. It includes, there's whole sections of the proposed regs and commentary that say, yes, it applies to physicians specifically. So that could be a real sea change. The first thing I can say is, number one, that's not happening quickly. I think 6 months before we actually saw anything close to a final rule. I think the comment period is going to be wild. And we talked about this last week because there's a real split in the physician community. The established practices want restrictive covenants in order to protect the value they've built. They don't want people to be able to just stay there for a year, take a bunch of patients and, their billing person or their front office person and go across the street and form a new practice. Younger, more recent physicians this is an inhibition on my ability to get some experience and then go somewhere else. So I think even within, I don't know if you hear anything from MedChi, but I think they're going to have to do a little bit of a dance because you have different groups of some physicians like them, some physicians don't. So the comment period is going to be wild. I actually, depending upon what happens, there may be some litigation. And the regs that are proposed would be a total ban. That could change dramatically between proposed regs and final regs. The example I gave last week, I'm also licensed in the District of Columbia. They passed their own law outlawing restrictive covenants, and there was litigation and it went kind of crazy. They had to withdraw the regs, and they came up with a compromise that said, yes, we banned restrictive covenants, but for certain highly compensated people, you allowed to have them. So I believe the definition in DC is anyone making over $250,000 a year. So if you're, a pediatrician making $110,000 a year, you're not going to be able to have a restrictive covenant. If you're an ophthalmic surgeon, making $500,000-$600,000 a year, they may be able to do that. So the regs could evolve. We have no idea what the final regs are going to look like. The other issue is kind of grandfathering. When the rule comes out, is it going to be all of them are gone right away? It doesn't matter if you have one in your contract. And I didn't talk about this last week, but most of the contracts we look at have a change of law provision. If something changes dramatically, this contract changes. So if the anti-kickback law changes or the Stark law changes and makes the way we pay you suddenly illegal, we have an obligation to go back to the drawing board and redo the comp so it's legal. And if either party can't come to an agreement, then you get to go your separate ways. There may be something similar for, I haven't seen it yet, but I think employers may start building that in, that, if it changes. And also, what do you mean by restrictive covenant? Does it just mean I can't practice medicine in another place? Does it mean I can't manage another practice? Does it mean I can't own a piece of another practice? So exactly what are you restricting when somebody goes somewhere? So I don't know if there's going to be any finality. My best guess is that they would there would be too much of a brouhaha if they just tried to wipe the existing covenants, because everybody would say, that was the deal I struck. That was the reason I decided to pay that person or recruit that person or do whatever. You're interfering. there's actually, everyone talks about the Constitution these days. There's actually a provision in the Constitution that says Congress is not supposed to interfere with private contract rights. Nobody ever talks about that. But so my best guess would be the final regs would say certain things are grandfathered in. So if you sign a contract between now and the final regs, you may have one and it may stay, you know, or there may be a change of law provision that says, yes, you're going to have one, but if the final regs come out, we can redo this deal to sort of more closely align, you know, because those provisions usually say what we want to do is renegotiate it to as closely as possible reproduce the deal we thought we had, but do it in a legal way. So this could be a major sea change, but it wouldn't shock me if there was some kind of an income cap, and it wouldn't shock me if there was grandfathering. And you know, once the final regs come out, everybody's going to know what the deal is. But I have a hard time believing we're really even going to know in 6 months. It's just it's a big political football. There's a lot of money involved in this, and we'll sort of see how it shakes out. But you know.
Well, as you suggested, it's a real balancing act for the American Medical Association. They have come out with comment about this, and they recognize that there are physicians on both sides of this issue. So before we close,
if I can say one last thing about that.
yes.
Last week we talked, there's a difference between a restrictive covenant that says you can't go and practice medicine in this other place, and a non-solicitation provision that says you're not allowed to go to your patients and say, you know what, this practice is terrible. The reason I'm leaving is because they have low quality. I want you to follow me to my new practice. Or, hey, we've got a fantastic person in the billing office. We've got a fantastic nurse practitioner. We've got a fantastic front office person. I'm going to take them. So there may well be a split between what gets banned is restrictive covenants that say you cannot personally go work somewhere, but these other ones, you know, the non-solicitation of patients or referral sources or office staff and employees, those may well survive. And those are also significant. I'm not a big fan of non-solicitation of patients. Patients should be able to go wherever they want, as far as I'm concerned. But some practices view the patient as their quote unquote asset, you know, their property. And if the patient wants to go and seek you out, that's fine, but you're not allowed to tell them, you know, yes, I'm leaving on this date and here's where I'm going. That's the reason it's really important to update your practice profile with the Board of Physicians, get yourself on the new practice website, you know, do any kind of promote. If you're leaving and you have non-solicitation, try to give yourself a digital footprint so people will be able to find you if they want you.
Well, thank you for that clarification. So we're going to end on a question about how to select a medical or healthcare contract attorney. But first, I saw Dr. Santi a couple of times you put your hand up. I wanted to see if you want to unmute yourself and ask a question about another topic. Okay. Then we're going to end on this question. Mr. Doherty, how do you select a medical or healthcare contract attorney? I have had attorneys review my contract and their weakness was clear, but I had already signed a contract to pay for services. What's your response?
That is a great question, because my partner and I joke that we would only employ roughly 15% of the lawyers that we've ever met. You know, and part of the problem is a law degree is kind of like a hunting license that lets anybody do anything. You know, we don't have an American Board of Legal Specialties where we get board certified in physician contracting. So, and a lot of physicians practice, the term my father used to use is door law. You do anything that comes through the door. You know, so you need somebody there. There's a health law section of the Maryland State Bar that may be able to make a referral. There's the American Health Law Association in DC that may be able to make a referral. Talk to other physicians that you know and trust. Who do you use? Do you think they're good? And ask. I mean, look them up online and ask to see their CV. Is this something they do? You know, we found one lawyer who said his specialties were healthcare law and beverage control. And we think he did more beverage control than healthcare law. You know, so try to make sure somebody has some experience and ask somebody around. Do not just take somebody you have a personal relationship with, your neighbor, a relative, a lawyer who did something else for you, real estate, a divorce, whatever it was. Try to find somebody who knows what they're doing. And, we obviously do this kind of thing, but especially, and one final thing about that, if you're relocating, somewhere else, you need to double check and make sure your lawyer is able to do that. So for example, if you are relocating to Delaware, Delaware bar rules allow me to look at that contract and advise you, and I've done that on numerous occasions. If you're relocating to New York or California, I would be engaged in the unauthorized practice of law. And for certain things, they're generic, certain things like restrictive covenants, that's heavily state dependent right now. So you want to make sure that the person is licensed there. If you're leaving Maryland, we know a lot of lawyers in a lot of other states that do this kind of thing. So if anybody was going to relocate, we don't need to represent you. If we can, we'd be love to. But if we can't, we just consider it our duty to try to find somebody that knows what they're doing that you can trust. So over the years, we've located people in the surrounding states and in quite a few other states that we can refer people out to so that they know they're getting somebody who speaks the language and knows what they're doing.
Well, thank you so very much. We really appreciate your contributions last week as well as this week.
My
These
pleasure.
are being recorded and will be available on Montgomery County Medical Society's and MedChi's YouTube channels. So on behalf of MCMS and MedChi, we thank you for joining us this evening. I know I put Jamie Doherty's email in chat, and I'm sure he would be happy to enter an agreement to review your next employment contract and to advise you on compensation models. So again, we thank you for joining us this evening, and we will be sending out an evaluation about this program, and we welcome your input and your ideas for future programming. So thank you again for joining us. We look forward to seeing you next month at our payer contract negotiations discussion. And so we wish you a good evening. Thank you so much.
Good evening, everybody. Thank you.